Thanks so much, Crystal. Hi, everyone. Thank you so much for joining us this afternoon. And welcome again to the Housing Cambridge virtual anti-discrimination training. This one's focused on landlords, property owners, and realtors. My name is Carolina Almonte. I am the attorney investigator for the commission. So I'm happy you're all here. Before we jump in, please keep in mind that the commission does not provide legal advice. We cannot provide legal advice. So nothing in today's presentation should be considered legal advice. So as Crystal mentioned, along those lines, if you do have questions, which we'll look at the end of the presentation, please keep them general. Please do not share any personal details or any other identifying information when asking a question. So we'll get started. So for today's session, I will start by giving a quick overview of the Human Rights Commission, and I will discuss our protected categories. We will then cover housing provider responsibilities and prohibited conduct. That will be followed by a discussion of common forms of housing discrimination complaints that we receive against housing providers and ideas for best practices. And we'll focus on disability complaints, family status complaints, and source of income complaints. Then I will wrap up by going over retaliation and what that means, as well as remedies and damages if a respondent is found in violation of our ordinances. And I'll go over other enforcement agencies. All right, next slide, please. So what do we do? As a Human Rights Commission, we are a city law enforcement agency. We're located at 51 Inman Street on the second floor in Cambridge, which is not the City Hall building, it's down the street from it. And our job is to receive and investigate complaints of discrimination that occur in Cambridge. So this presentation is focused on housing complaints, but we also accept complaints of employment discrimination, education, and public accommodations discrimination. Our job is to enforce two city ordinances. So the Cambridge Human Rights Commission, and that's where the employment and public accommodations and education complaints fall, and the Cambridge Fair Housing Ordinance. Our ordinances prohibit discrimination based on protected categories, which I'll discuss in more detail later on. So now that you have a general understanding of the Human Rights Commission, I'll go over what jurisdiction means. So jurisdiction is basically the authority granted by our ordinances to the commission to investigate and rule on legal matters. So that's based on the subject matter of the case and the geographical region in which the issue took place. So at the commission, we can accept complaints of discrimination only if they occur in Cambridge. So what that means is that a complainant can live outside of the city, that's fine. But the respondent housing provider or the individual alleged to have discriminated must reside in Cambridge. You can still get help, which I'll go over at the end, from another agency if that's not the case. Also, the alleged discrimination must have occurred within the past 180 days, which is about 6 months. There is an exception if the conduct first occurred prior to 180 days and it is ongoing. And the last element that has to be proven to fall in our jurisdiction is that the alleged discrimination must have been based on a complainant's membership in a protected class. So as I said, our role is to investigate complaints of discrimination. We do act as a neutral investigative agency, so that means that we do not represent either party. There's no cost for a complainant to file a complaint with us. Also, no attorney is required to represent a complainant or a respondent, but either party can obtain an attorney if desired at their own cost. So overall, the way our process works is that it begins initially with an interview and then a complaint draft. Once a complaint is finalized, it is served on the name respondent or respondents, and the respondents have 10 days to respond after receiving that discrimination complaint. So after that, I typically would interview witnesses, review documents, review case law, just look for any kind of evidence that could prove either side of a complaint. I also endeavor to mediate many of our complaints, which means, see if there's a resolution that both parties can agree to. And that could happen at any point in the process. If mediation is unsuccessful, we would move forward with our investigation. If it is successful, I would draft a settlement agreement, and then the matter is closed. If it's not successful, I would move forward with my investigation and eventually draft a determination of either probable cause that discrimination occurred or a lack of probable cause. The other thing I'll note is our process is not intended to be adversarial. Our goal isn't necessarily to punish respondents, but rather eliminate violations of our ordinance. So now, as I mentioned, I'll go over the protected categories and what they mean. So you'll notice that there's many similarities between what the state recognizes and what the city of Cambridge recognizes. The bolded ones you see on this slide are the ones that are not protected under the Federal Fair Housing Act, but we would still accept that complaint. Before going into what each of these mean, it's important to note that both majority and minority traits are protected. For example, men are protected from sex discrimination as well as women. Also, you could be discriminated if you're a member of a group, perceived to be a member of a group, or associated with a member of one of these groups. Also, please note that, all of these protected categories apply to ads, public housing, private realtors, and landlords. So just going through what each of these mean quickly. First is active military personnel or veterans. They are protected under our ordinances. So some examples might be being denied a housing opportunity or charging a higher security deposit for a veteran. Age is 18 plus. So if you're old enough to enter into a contract, you're old enough to sign a lease. Disability, I'll go into more detail later. It could be either physical or mental. So that means folks are protected if they have an impairment, a record of an impairment, perceived to be impaired, or by association. Gender identity are folks who are transgender or in any way gender nonconforming. Sexual orientation covers gay people, straight people, bisexual, pansexual, etc. Marital status and familial status. So that means, regarding marital status, living with someone, married or not. And family status comes up often with lead paint cases, which I will cover later on. The difference between ancestry and national origin is that national origin is where you are from. So that could be Australian, Hungarian, Zambian, and ancestry is your family background. So both are protected. Public assistance or source of income means that you can't be discriminated based on the receipt of any form of public assistance. So that could be Section 8, it could be SSI, it could be SSDI, etc. Race and color. So color is very literal. That means how much melanin we have in our skin and oftentimes how other people identify us. Race is how we identify. Religion covers any religious beliefs, even ones that are not common, are protected. So that means you can't discriminate against a religion you've heard of, or a religion you haven't heard of, or as someone who's an atheist. Sex means you can't discriminate based on sex or gender. And keep in mind, this also includes sexual harassment in a housing environment. So our ordinance covers most housing in Cambridge, but can on rare occasions exempt owner-occupied buildings. That's called Miss Murphy's exemption. So that's when there's no more than 2 units that's outside of our ordinance. The ordinance also doesn't cover housing operated by religious organizations, private clubs that limit occupancy to members, and single-family houses sold or rented by the owner without the use of an agent. Also, the housing providers specifically that are covered are owners, landlords, and their employees, any real estate agents or agencies, apartment managers, management companies, banks, mortgage companies, appraisers, homeowners insurance companies or associations, and public housing authorities, which I want to just make a note on. So we can accept complaints against the Cambridge Housing Authority. It is not a City of Cambridge agency. So generally, if you're on a deed, you may be liable. So this could include an absentee landlord. And you also can be liable if an agent carries out a discriminatory policy on your behalf. So on this side is just general housing provider responsibilities and real estate professional responsibilities. So both can't establish discriminatory terms or conditions in a rental, can't deny that housing is available, can't advertise that a property is not available to persons of a certain protected class, and likewise cannot instruct a licensed broker or salesperson acting as their agent to convey any limitations. So we'll go into more details about specific responsibilities, but those are general ones that we think are important. So housing providers cannot do any of the following when renting or selling houses and apartments. You may have seen some of these words before. We'll just go through each of them with a few examples. So the first is refusing to sell or rent. This is pretty self-explanatory, but housing providers should provide equal opportunity to obtain housing in Cambridge. So keep in mind that many less direct actions can still rise to the level of refusals to sell or rent, such as ghosting a prospective applicant or providing incorrect information about a sale or a rental. An example could be a property manager refusing to rent an apartment to a single woman, but he would rent that apartment to a single man, or a landlord refusing to rent an apartment to a blind woman because she has a service animal. Steering is conduct designed to influence a prospective tenant's housing choice based on a protected class. So evidence of steering is often gathered through the use of testers, which are people who go out into the community and they collect data for us by pretending that they're members or being members of a protected class to see if they're treated differently than someone who is alleging discrimination. So that could look like, regarding steering, an agent working with a Black family and determining that they're not a good fit for a neighborhood. And therefore that agent nudges them to a different neighborhood. Blockbusting is different. So that refers to the suggestion that a person should sell or otherwise dispose of their property, usually below market value, because of a particular protected class of people moving into a neighborhood. So that's, when a real estate agent alerts members of a neighborhood that it is changing. So they should sell their property, they should get out of there. That is bad. And then redlining, that's a practice of denying a creditworthy applicant of a loan for housing in a certain neighborhood, even though the applicant may be otherwise eligible for a loan. So for example, a lender refusing to lend money to a house buyer because the house he wants to buy is in a minority neighborhood. So what happened is banks made it basically impossible or nearly impossible for people living in low-income neighborhoods to obtain a mortgage because of the high default rate in that neighborhood. So this practice is called redlining because in the past, some of these financial institutions would literally draw a red line on a map, establishing neighborhoods where they wouldn't provide services. So besides these 4 examples of prohibited conduct, housing providers are also prohibited from creating different terms or conditions for different classes when renting or selling, denying participation in services related to housing, making housing unavailable or lying about the availability of that housing. And also they can't provide amenities that are different or different accommodations to different groups. So now that we went over some examples of prohibited conduct, we will now go over some of the common complaints that we accept for filing from complainants. And many of those are from complainants with disabilities. So first, what is a disability? This is important for housing providers to keep in mind. and generally know that a disability is either a physical or mental impairment that substantially limits one or more major life activities. So based on this definition, a broken arm that heals normally would likely not be considered a disability. Additionally, complainant must have a record of such impairment, or they are perceived as having an impairment. A perceived disability does not give rise to an accommodation requirement, but can be the basis of a discrimination claim. Also, remember, disabilities do not need to be visible. Even though the picture on the slide is of someone in a wheelchair, that's of course not required. When determining if a disability is a substantial limitation, what we would look at is the nature and severity, duration or expected duration, and if it's permanent or long-term regarding its impact. And these are just some examples of what a major life activity could look like. So that could be caring for oneself, walking, seeing, hearing, learning, working, sitting, concentrating, interacting with others. This is not an exhaustive list. These are just some examples of what may apply. There are some exclusions that apply regarding who counts as a person with a disability. The first is individuals with substance use disorders who are actively using those substances. Keep in mind that recovering addicts could be considered people with disabilities as it pertains to disability discrimination. Also, personality traits such as irritability, unless disability related, would likely be excluded. And the third is uncomplicated pregnancy. So it could be protected under sex or family status, but normal pregnancy wouldn't automatically be considered a disability. However, it could be if it's proven that there's complications involved. So what can prospective tenants with a disability ask for? You may have heard of both of these, a reasonable accommodation or reasonable modification. So to go into more detail, a reasonable accommodation is when there's a change to a policy or practice that is necessary for a person to utilize and enjoy a dwelling to the same extent as a person without a disability. So some examples would be an exception to no pets policy to allow for an assistance animal. Keep in mind, it could be a service animal or emotional support animal, or providing a reserved parking space. It could also be assigning a parking space to a handicapped tenant near the tenant's building entrance, notwithstanding a first come first served policy, or waiving a rule that bans vans in a parking lot if it's necessary for that person's transportation. An accommodation is different than a modification because that means a tenant is asking you for a structural change regarding a modification to existing premises that is necessary for a person to fully utilize and enjoy a dwelling to the same extent as a person without a disability. So some examples of this would be building a wheelchair access ramp, lowering counters, cabinets, or alerting walkways to provide access to public or common areas, or altering rather. It could be installation of grab bars in the bathtubs, or adjustment to toilet seats. It could be widening doors. It could be installing a flashlight in lieu of a doorbell. So those are all examples of modifications that a tenant can ask for. One question we often get is who pays for reasonable modifications? So generally, if a housing provider receives government funds, they must pay for the reasonable modification. Otherwise, a tenant generally would pay. The other thing I'll just touch on is that we've seen complaints from complainants who are deemed hoarders, which is a disorder, and as such, they're entitled to protections under our ordinance as people with either mental or physical disabilities, such as a side note to keep in mind. So once a housing provider is on notice of a need of an accommodation or modification, what they should do is institute an informal interactive process with the tenant. This also includes prospective tenants. So if a tenant is applying for housing and they have alerted you to an accommodation requirement, the process begins there. They don't have to be an active tenant. And what this process should do is it should identify potential reasonable accommodations to address a tenant's particular limitations. A request for a doctor's note can be appropriate if a disability is not obvious. Also keep in mind that this could be from any medical provider. It could be from a therapist or a social worker. It does not have to be from that person's doctor. And it also just has to work, but not all the bells and whistles are required. There's also no requirement that these requests have to be in writing. So the key takeaway here is that the focus should be on the needs of the tenant or prospective tenant, not on intrusive questions regarding that tenant or prospective tenant's disability. So that brings me to my next point, which includes examples of problematic questioning. So if you're a housing provider, you must treat all applicants and tenants with disabilities in the same way as those without a disability. You can't request medical records or ask directly about an applicant's disability or guide a tenant to a specific unit. It's also illegal to ask a tenant if that tenant is capable of independent living. And you also can't require a pet deposit or pet rent for a service animal or emotional support animal, charge extra fees, or higher rent because of that tenant's disability. These are also just some questions that you should be on the lookout for that could be problematic. So what is your disability? What is your medical history? How often do you use your wheelchair? How did you become disabled? Are you taking any medications? Will your disability hinder your ability to pay rent on time? So even though you can't ask directly about an applicant's disability, you may ask for information to show that they meet the same requirements as any other tenant with or without a disability. So regarding best practices, if the same questions are asked of every person, a housing provider, like I said, may ask a prospective tenant about their rental history or other relevant information. Property owners and homeowners associations are required to make reasonable accommodations to any rules or regulations governing housing developments that are necessary to permit the tenant to enjoy the premises fully. And lastly, a housing provider may condition modifications to the interior of a unit on the tenant's agreement to restore the unit to its original condition when the tenant's occupancy ends. Another category of complaints that we receive often are from families with children. So under our ordinance and the Fair Housing Act, housing providers cannot discriminate based on family status. Federally, it's called familial status. Family status is a condition of having children below the age of 18 years old living with a parent or another person having parental custody. This definition also covers pregnant women. There is an exemption from family status discrimination for housing for older people. So that includes certain senior housing facilities and communities. So examples of family status discrimination that we see are advertising that prohibits children, refusing to rent to families with children, requiring families with children to live on specific floors or in specific buildings or areas, imposing overly restrictive rules about children's use of common areas such as pools, hallways, open spaces, gyms, evicting families once a child joins the family. So that could be after birth, adoption, or obtaining custody. The other thing I'll just touch on here is that it's okay to have reasonable limits regarding occupancy standards. So regarding the number of people that could live in a rental home. However, when it comes to families with children, you should have reasonable policies. So HUD has ruled that usually what that means is allowing 2 people per bedroom with 1 additional person in the rest of the unit. So in a 2-bedroom apartment, you should allow a family of up to 5 people to live there. Or in a 1-bedroom, you could allow a family of 3. But generally, just keep those in mind and that there's some flexibility regarding occupancy standards. So here are some problematic statements that could be evidence of discrimination as it obtained as it relates to family status discrimination. So the first is, saying this building is not safe for children. You could take younger children, but teenagers will disturb other tenants. Sure, we rent to families with kids, but we'll need an extra security deposit. Yes, we allow children, but we'll need to charge more rent for each kid. Children are only allowed in the basement or first floor units. This complex isn't suitable for children. There's no playground or open space for them to play. There are no children here. Your children won't have anyone to play with. Sorry, a parent and a child cannot share a bedroom. We want to protect your child. We have lead paint. Sorry. So that's another issue that often comes up with family status discriminations is complaints is regarding lead paint. So many properties constructed prior to 1978 may still have lead paint. So studies have shown that lead paint can be harmful to children. Therefore, landlords must de-lead their properties if children under 6 will be living in them. If a tenant is pregnant, you must also de-lead the property. And that's not just when the baby arrives, as soon as you learn of the pregnancy. So regarding housing provider responsibilities, the first is disclosure. So property owners must disclose to tenants any knowledge of lead paint or lead paint-based hazards in the home. If there is lead paint discovered, property owners generally have 2 options. So the first is full de-leading compliance. So the way that works is you would first hire a licensed lead inspector who would test the home for lead and report all lead hazards. And then any de-leading work must be done by a trained and licensed professional. And then afterwards, a licensed lead inspector would re-inspect, and if all goes well, you would then receive a letter of full de-leading compliance. Alternatively, housing providers could use interim controls. So basically, that means that it's a temporary method. So you would still need to hire a licensed risk assessor who will explain what work needs to be done. And then after a risk assessor approves the work, you would receive a letter of interim control, and that lasts up to 2 years. And then afterwards, then you would receive a letter of full compliance of de-leading should you complete all of the work. The other thing I wanted to share is that in the city of Cambridge, income eligible households may be able to receive low interest financing to eliminate lead paint hazards through the City of Cambridge Home Improvement Program. The last thing I'll touch on is liability. So, if you don't either fully de-lead a unit or do an interim control and an tenant is harmed, they could sue a landlord for their damages. So that would include any medical costs associated with lead paint poisoning, and that of course can be very costly. Our recommendations for best practices regarding family status complaints to avoid them is 1, if a housing provider has rules that limit children's access to certain areas, they must be reasonable. And they also must be based on legitimate health and safety considerations. They can't be overly strict. So once again, that's like sauna, pools, fitness centers, game rooms, any areas like that. And the second is that if state or local laws do not include occupancy limitations, housing providers may create their own limitations as long as those limitations do not unreasonably limit or exclude families with children. So source of income complaints, that's the last kind of big area of complaints that we tend to receive. By the commission, we'll go over what that looks like next. So what is source of income discrimination? It is an unlawful discriminatory practice to deny, directly or indirectly, any individuals the full and equal enjoyment of housing, including the rental or purchasing of housing based on the source of income of that individual. So landlords are not allowed to discriminate against people who derive their income through different public benefits, such as Section 8, veterans benefits, Social Security benefits. I'll also note that this protected class is protected by our local and state laws, but not by the federal law. So can a housing provider treat voucher holders differently from other tenants? No. So what that means is that landlords, property managers, real estate agents, or brokers cannot refuse to rent to voucher holders, refuse to negotiate, set different terms or conditions of rentals, refuse to comply with the requirement of a rental assistance program. For example, refusing to provide the necessary paperwork that would be required. They can't tell a voucher holder that housing is not available to rent in order to avoid renting to a property to them. They also can't place advertisements for housing that says, people with vouchers cannot apply, people with Section 8 cannot apply. And lastly, they can't use certain criteria or procedures that would exclude voucher holders. For example, by requiring evidence of employment-based income or requiring voucher holders to pass different credit or background checks different from other renters without vouchers. So these are examples of problematic comments or statements regarding those with alternate sources of income. For example, we don't take people on SSI. I don't know anything about the voucher process. 2 years steady employment required. I found that people on Section 8 don't fit in well here. We don't give home loans unless you're employed full-time. Even if you have a housing choice voucher, Section 8, you must make 3 times the full rent. Don't bother applying if you don't have a job. One thing I'll note is that we see a lot of issues regarding housing providers claiming to misunderstand the voucher process. And we really do encourage those housing providers to reach out to housing authorities for clarification before turning a prospective tenant away. There's also an abundance of print and electronic materials that thoroughly explain the Section 8 process, Section 8 program, and other public assistance programs. Additionally, keep in mind, it is unlawful to deny a rental application because of the applicant's partner's or family member's lawful source of income. Ask whether applicant is receiving any government assistance and then denying the application. Or like I mentioned before, you can't advertise with the phrase no programs or no Section 8 available. Those are all problematic and discriminatory. So regarding best practices regarding source of income complaints and to avoid getting those filed against you, the first is that housing providers can set financial and credit qualifications. One thing we'll add though is that we do encourage alternative models for credit screening and query. And some of the examples could be utilizing references rather than credit scores, or looking at payment history for monthly bills or insurance payments, medical payments, school tuition, just other kind of qualifiers than relying so heavily on credit scores. Also, qualifications and inquiries must be applied equally to all applicants. So this shouldn't be influenced by source of income or any other protected classes. As I mentioned before, we really do encourage housing providers to understand and become informed about Section 8 and other relevant federal and local subsidy programs. Learn what payment standards mean and how they're different based on zip codes. Security deposits are okay, but keep in mind that inspections are required before a tenant can move in. And the last, of course, is just, please refrain from ghosting prospective tenants. They're all looking for housing. We really do encourage housing providers to respond to housing requests in a professional and courteous manner, because we hear issues of that come up often. So in terms of best overall practices, the first is, like I said, treat all prospective and current tenants with dignity and respect. The other big one, make sure you're consistent with screening potential tenants. So don't decline a rental application for any reason other than a prospective tenant not meeting your stated and evenly applied qualification criteria. Have the same qualifying standards for every renter. Your guidelines should be clear, visible, and impartial. Require the same documents, the same fees, the same referrals, and any other information from every prospective tenant. Also, it's helpful to establish a clear maintenance response policy. We don't have this on here, but I would also encourage landlords to have a stated reasonable accommodation policy to make the process seamless for any interested tenant. And lastly, provide fair housing training to all of your employees and associates. Be sure you protect everyone involved in your business by providing regular training on fair housing matters. The more you know about laws and provide guidance to your team, the more likely your employees will comply with the laws. The other thing that is very important is to note that retaliation is covered under our ordinance. So what that means is that it is illegal to retaliate against a person for making a complaint, for testifying, assisting, or participating in any manner in a proceeding under a complaint process at any time. And that means even after an investigation has been completed. It's also illegal to retaliate against any person because that person reported a discriminatory practice to a housing provider or housing authority. Keep in mind that this also applies during the housing search process. So retaliation could look like a tenant having previously filed a complaint against a landlord being treated differently, or a prospective tenant who was then ignored or denied after applying to a different property owned by the same management company. Some other examples could be a resident complaining to a manager that she received a 10-day notice because of her race, then the manager getting angry and giving her an eviction notice. Another example could be a resident was a witness to a complaint investigation, someone I spoke to, and then the manager says he's going to keep an eye on her. So now we'll jump into remedies and damages, everyone's favorite part. Keep in mind, the first is that a lot of people can be held liable. So this applies to both individuals and organizations. So of course, individuals are the individual people that are alleged to have discriminated or violated our ordinance, and whatever organization, management company, realty company, public housing authorities that they're a part of. Also, liability gets triggered not just with management to tenant claims, but also tenant to tenant claims. So we see that in complaints of harassment. Just keep in mind there is an affirmative duty for landlords to mitigate that harassment, which we didn't discuss much in today's presentation, but that's just something important to note. Regarding damages, keep in mind that could be emotional distress damages, out-of-pocket expenses, affirmative relief, attorney's fees, and public interest provisions. If a case goes to hearing at the commission and a commissioner finds that a respondent engaged in discrimination, the commission can award damages to a complainant, which could be moving costs, it could be the cost of storing their furniture, it could be costs of alternative housing or space that they had to utilize because they were improperly denied a housing opportunity. And commissioners can also assess civil penalties to the respondent, not to exceed $10,000. So that's what could happen if a complaint goes to hearing. Okay, there's our governor. So if probable cause is found, so that means we found evidence of discrimination, either party can request to send their case to the Massachusetts Attorney General's office for investigation and filing in Superior Court. So if a case is filed in Superior Court, that means a respondent housing provider could be subject to the damages under our state anti-discrimination statute, which can be substantial. If neither party wishes to send it to the AG's office, what would happen is that it would remain with the commission and it would proceed then to our public hearing process if it can't be mediated. This slide just goes over some of the other enforcement agencies. We sometimes get mixed up with the Mass Commission Against Discrimination, which is our state equivalent. So they have jurisdiction to accept any discrimination complaints that happen in the state of Massachusetts. and their statute of limitations is 300 days. Housing and Urban Development, HUD, that's our federal fair housing agency. The other thing I'll note is that they've considered us substantially equivalent to the Fair Housing Act. So they give us authority to basically investigate complaints on their behalf regarding protected classes that are federally recognized. And then we're at the bottom there. As I mentioned before, we covered the city of Cambridge, and our jurisdiction is to enforce our ordinances or our local laws. And our jurisdiction is 180 days. So that brings us to the end of our presentation. We wanted to make sure to share our location. As I mentioned, we're at 51 Inman Street on the 2nd floor. That is the best number to call if you would like to call for a phone intake. Also, I encourage you to look at our website where you could fill out an online intake form. That might be the easiest way to file a complaint with us, and then I could schedule a call to meet with you. So thank you all for being here. I think now we'll have time to take some questions.
So Carolina, Phoebe answered some of the questions that were more about black box that was is at the bottom of the screen. It was for the captions. But if anybody has questions now, feel free to put them in the Q&A box. You just hover down at the bottom of the tab and add in your question there, or you can raise your hand and we can give you an opportunity to speak if you'd rather do that. We'll give everybody a couple minutes to think of their questions. Let's see. Any doesn't look like anybody's got a question, but Carolina, something that I have a question about is, so if anyone's a realtor or property owner here, what can they do if they have questions after they received notice of getting a complaint?
So they are more than welcome to call me directly. As I said, I'm a neutral party. I don't represent a complainant, so I'm happy to explain our process. We also have our rules of procedure on our website, as well as our ordinance that goes through just, more detail how we operate. But I'm more than happy to speak directly to anyone who gets a complaint to explain the next steps or answer any questions.
Great. Let's see. If there aren't any questions, we can end early, but I want to give everyone an opportunity. Again, you can raise your hand and then I will be able to do oh, here we go. We have one raised hand. Hi, you can go ahead and speak. You might want me to unmute yourself.
Hi there, how you doing?
Doing well, thanks.
Excellent. I had a question. There is a building that I manage some units in where the condo association of the building does not allow pets. But what if somebody was coming in that was trying to get a reasonable accommodation where because I'm managing the property, I don't have authority over the condo association, but I also don't want to be not in compliance?
That's a great question. So, when I describe the definition of reasonable accommodation, is a change to the policies. So even though you mentioned that the condo association has a no pets policy, if there is someone who's requesting a reasonable accommodation to have a service animal or an emotional support animal, that should be granted. I understand you're saying you manage the property, but that doesn't automatically make you liable. We would basically look at did the condo association start engaging in that interactive process? Did they have knowledge of the complainant's disability, and kind of go from there? Does that answer your question? So generally that could potentially be a case just against the condo association.
Okay, thank you.
Anyone else, please feel free to raise your hand and I can help this process along. Or if you'd much rather just enter it on the Q&A box. We have about 10 minutes, so there's plenty of times if anyone has questions.
I'll also add, if anyone wants to chat with me after the presentation, I'm more than happy to chat at any point.
Okay, I'll give it another, I'm just double checking everything gets covered. Okay. All right, well, I think we're all set unless someone gets excited and wants to ask a question. But I'm gonna, once I end the webinar, everything will disappear. So feel free to reach out to Carolina if anything comes up. And you will receive the slides, correct? Am I saying, yeah, okay. So anyone who registered will receive the slides and we'll let you know once this recording is available on the city's YouTube channel. Also, I want to just let people know that if you go to the Housing Liaisons landing page, you'll be able to see all the previously recorded webinars there. And we had another similar webinar specifically on accepting voucher holders. Okay. Cool. All right. Well, everyone have a good day and enjoy what little light there is. Oh, there's one more question. Let me see. Oh, thank you. Oh, thanks. Nice. All right. Well, everyone have a good night.
Thanks,
All right.
everyone. Take care.
Bye.